about another area of your advocacy. In a legal challenge to Arizona House Bill 2023, which prohibited ballot harvesting, you argued the bill not only had the incidental effect of lowering minority turnout, but that it was actually, quote, designed to suppress voting in minority communities. As you know, the Supreme Court 6-3 rejected that argument. Do you still believe that prohibitions on ballot harvesting are designed to suppress minority votes?
Thank you, Senator. The Supreme Court in Brnovich v. DNC set forth the guideposts for determining when a law violates Section 2 of the VRA. They've indicated the factors to look at include opportunity to vote, openness of voting.
Okay, I recognize and I'm aware what the Supreme Court has held, and so it rejected the argument. I'm asking you, do you believe, you wrote as an advocate, that prohibitions on ballot harvesting are designed to suppress minority votes? Do you believe that as a factual statement?
Senator, the statements that you're reading from were written in an amicus brief as an advocate, filing that on behalf of my clients. As a judge, I would apply unreservedly, fully, and faithfully the precedent set forth by the Supreme Court.
So that brief you filed on behalf of a group called Fair Fight Action, is that correct?
Senator, I had two clients in that for that amicus brief. It was Fair Fight Action and the Arizona Voter Empowerment Task Force.
So has Fair Fight Action ever disputed the integrity of an election?
Senator, I am not. I'm not aware. I haven't studied that. I don't know.
You don't know?
I don't know.
But who started Fair Fight Action?
My general understanding is that Fair Fight Action is an organization that was started by Stacey Abrams.
And Fair Fight Action disputed and litigated against the integrity of the election in Georgia in 2018. You're right, it was started by Stacey Abrams. And in fact, Fair Fight Action argued in court that the voting machines in Georgia actually switched votes from her to Brian Kemp. Is that correct?
Senator, my involvement with Fair Fight Action extends to filing that amicus brief in the Brnovich v. DNC case about the Arizona election laws. I was not involved with and I'm not familiar with Stacey Abrams' gubernatorial campaign from 2018. I believe Fair Fight Action was actually created after that election, but again,
but it was created to challenge that election. It was part of Stacey Abrams' ongoing efforts to maintain that she was in fact the governor of Georgia, notwithstanding the voters of Georgia disagreeing and voting for another candidate. Let me ask you, the last major bipartisan examination of voter fraud was chaired by Democratic President Jimmy Carter and Republican Secretary of State James Baker. The Carter-Baker Commission concluded that prohibitions on ballot harvesting protect election integrity because ballot harvesting invites voter fraud. Do you believe Democrat former President Jimmy Carter was actively trying to suppress minority votes, as you argued the provision in Arizona was doing?
Senator, thank you for that question. I'm not familiar with the facts that you recounted, but what I can tell you is that I would faithfully apply the rule of law from the Supreme Court and the Ninth Circuit precedents if I'm confronted with a case that challenged election laws.
Final question, because my time's expired. You wrote that brief without examining what the Carter-Baker Commission recommended? You made that allegation about ballot harvesting without even knowing what the Carter-Baker Commission said?
Senator, again, as I sit here today, I'm not familiar with those facts. But like I said, I am committed to the rule of law and to implementing the Supreme Court's precedent with respect to how to evaluate state laws that are relating to ballot collection or any other laws that are challenged under Section 2 of the VRA.
Thank you.
Senator Tillis.
Thank you, Mr. Chair. Congratulations to both.